Hi everybody, welcome to another Firebrand video. It's been a while since I've recorded and I'm really coming back because I want to offer some advice on completing the Code of Practice Consultation 2025 from the Equality and Human Rights Commission. So for those unfamiliar, the Equality and Human Rights Commission have prepared a draft code of practice which they're consulting on regarding the definition of sex in the Equality Act. So the guidance that becomes statutory guidance, so guidance that organisations are obliged to follow following the Supreme Court's ruling. So you can see they've outlined several different changes. I'm going to go back to the beginning page. We can have a look from here. So you can see a link on the main page of the Equality and Human Rights Commission. It's not always as prominent, I don't think, but you should be able to find it using a search. But you can see at the moment it's on the front page, the consultation for the new Code of Practice. I'm going to read about it and click to complete my review. You'll see there's some introductory information, and then it segments the changes into different chapters and then addresses them individually. You can see you can complete the survey by clicking on the form. So here's the form, and when you click to complete the form, you click to say yes, you want to complete it. You can respond as an individual in this case, and you can click any of the relevant boxes for protected characteristics. So if you're writing about it in relation to your disability, your age, or any other aspect, you can click those where relevant to. And then there's a notice saying you don't need to provide feedback to all sections. And then do you want to provide feedback on the first aspect? Now this is on the legal definition of sex throughout the Code of Practice. That's moving back to the consultation, that's just here. This part that applies across. So this is referring to the updated legal definition of sex. There doesn't appear to be a great deal of contention here, but there are a few points that I think are worth raising as part of the next question. So I'm going to click on yes, and then you'll see the question that we really have is to which extent that we agree or disagree with how clear the statement is, and then is there anything you would change to make this update clearer. You'll notice that each of the questions or each of the questions on each update are all phrased in this manner with a do you agree that it's clear, and how could it be clearer. Obviously they are trying to dissuade you from writing any content on problems with the application or any other issues other than how clear they're making it. Now that's obviously a big issue and probably the first of my complaints, but still. Okay. Another issue, if you look at the definition, is that it doesn't address how the Gender Recognition Act interacts with the equality legislation. So which pieces of which activities or which aspects are related to the definition of biological sex or legal sex, because the Gender Recognition Act specifies for all purposes. So I think, being as that is now no longer the case, I think it is important at this stage for them to be clear on that. There are issues that touch on this later on, and so a clear definition of which things are modified by the ruling and which things aren't, I think, is important. What else? It doesn't address the practical consequences for GRC holders. So are there any benefits now of holding GRC? There's not really any addressing of this matter. It should clarify the idea of sex versus legal sex. The code now defines legal sex as birth sex. Chapter 2 also defines sex, as in the protected characteristic, as biological sex at birth. And the update needs to clarify if legal sex and the protected characteristics of sex are now all entirely synonymous and interchangeable. And if they are, then it needs to be very clear that this is the case to avoid issues later on. There's also no application of intersex. There's no acknowledgement of intersex conditions here, and there really should be. So, yeah, that's also an issue. Yeah, it should really address transitions, so as in transitional periods. So obviously, if these changes are being implemented, then it needs to be addressed over what period they are to be implemented. You know, people have been using these rights for many years, and so do we just expect them to just suddenly stop? Or, you know, there's also covered, and that would be in issues that cover all of the amendments and all of the sections. So those are the issues that I have listed for question 6. I'm going to continue from now, and we can have a look. Oh, it wants me to carry on. I'm just going to carry on from this one. And then, so next we're moving on to change 2.1. And in question 9, we'll see we move on to section 2.1, changes from section 2.1. That's new content on gender recognition certificates and asking about sex at birth. This is like a really problematic section. You can see some of the additions here. Act define gender reassignment as protected characteristics. Okay, the first issue that I have is with I guess just the language. I mean, I'm going to move to 2.17 for an example of this. This means that in relation to the Act, a person's sex remains their biological sex, whether they have a GRC or not. This is also referred to as sex at birth or birth sex in this code. For example, a trans man with a GRC as a woman and a trans woman with a GRC as a man for the purposes of the Act. Now, while I accept that the ruling said that sex is based on biology for the purposes of the Equality Act 2010, it didn't dictate that they had to use, you know, such direct language. They didn't have to choose that particular example. They didn't have to specify that in that they've chosen to select deliberately cruel and offensive language. And I think that probably typifies my thoughts over the whole of the changes. I think it's worth noting that. In this section, they rely more on abstract forms of discrimination to protect trans people. A trans person will be protected from discrimination because of gender reassignment, whether they have a GRC or not. And they also make the argument that being perceived as a trans person offers protections as well. But a trans person will also be protected from sex discrimination, whether they have a GRC or not. They'll be protected from sex discrimination that is based on birth sex. They'll also be protected under their acquired gender, where they suffer discrimination. Actually, what they're saying is being perceived to be female, but relying on these sort of more abstracted forms of discrimination like association and perception, it places a more significant burden on the trans people to prove their case after the harm has occurred. And I think really what the code should be doing is aiming to prevent harms by allowing safe facility access. And the code should focus instead on preventing situations that lead to discrimination and harassment, and not describing more complicated, convoluted legal routes to address it after they've happened. I think if you're going to recommend that people obtain sex-based data as well, then this is data that people aren't used to collecting. We haven't previously had to collect it. So I think also in this section, it's incumbent on the EHRC to remind service providers of the special status of this information, and that there are special considerations for its acquisition, storage, and processing, and those aren't present in this section here. Yeah. Okay, and again, only asking about clarity, they're really shutting down or attempting to shut down conversation later on. Now, I'm going to refer directly to the questions. However, I will continue to call out the question numbers. So later on, when I cover the particular question numbers, what I'm referring to are these questions here. I'm going to talk specifically about the open-ended questions. So as soon as I say I'm going to answer it, I'll get a Likert scale for agree, disagree, and then I'll get an open-ended question. This is the one that I'll be referring to. Will be the open-ended question. You can assume that I'm going to be choosing strongly disagree on every question. And I'll call out those question numbers. So let's move on now. We've had a look at 2.1. We're going to move on to content asking about sex at birth. This is a really problematic section in which they include guidance about how to approach people and say, I don't think you're the gender that should be using these facilities. Yeah, I mean, I'm tempted to read the whole thing out. It's all pretty abhorrent. But yeah, you can read for it yourself. My key issues with this section are that after encouraging people to obtain information on people using facilities, it says that you only really need to do that to justify where obtaining information about birth sex is not necessarily in proportion, asking a person about their birth sex may risk unjustifiably interfering with their human rights. Now, this seems to be a supportive statement. However, requests about birth sex are more likely to be justified where it's necessary and proportionate for a service provider, for example, those exercising public functions or associations to know an individual's birth sex, to be able to discharge their legal obligations under the Equality Act. And that includes things like just having toilets that are gendered. So yeah, it doesn't really offer any protection. It's certainly not a great deal of protection. Yeah. So one thing that's particularly problematic about this, given that it's asking you to collect this information in a broad range of situations, it's also saying it may be reasonable to ask for evidence of birth sex or biological sex. As we know that these are synonymous. And saying that these could be grounds for exclusion from services, on the basis of people aren't being believed that they're the gender that they say that they are. And it gives an example. It gives an example of this, an explicit example where somebody goes up to somebody, in this case, are apparently a trans woman. But there's no reason to think that this wouldn't be a cis woman who had perhaps a couple of masculine features, perhaps just by fate of genetics, or perhaps by virtue of having a condition. There are numerous conditions that can lead to the appearance of male traits, in the same way that there are things like gynecomastia that appear in males that lead them to have female appearances. In any case, the example describes somebody going up and confronting an individual about which facilities that they're allowed to use. And in this situation, the person confirms what their birth sex is, and then the receptionist, everybody's happy, they're relegated to some different facilities. However, it's unlikely to happen like this. And if we're approaching people and saying that birth certificates aren't necessarily accurate, and that employers are obliged to um, are obliged to uh, confront on their biological sex, then where does this lead us? Does this certainly feels like it leaves us open to mandatory genital checks, or it certainly leaves us open to some people interpreting it in that way. And I think that the EHRC haven't included the fact that genital checks shouldn't be an option in their guidance is, at the very least, a glaring oversight that shows an absolute lack of attention to detail and a lack of proper consideration for the safety of trans people, intersex people, and women and girls, especially. Um, because these are the people who are most likely to face the brunt of this. So that's another point. It doesn't prohibit that. It also doesn't address the risk of racist misapplication, because I mean, essentially what we're talking about here is somebody confronting an individual in a toilet based on stereotypes. There's absolutely nothing about this situation that is going to be based on the frontline staff who are going to operationalize these kinds of checks. They're not going to have DNA testing machines and estrogen level machines and testosterone level machines. Not that any of these things would necessarily be accurate. How are they going to be choosing who to approach? It's going to be on the basis of stereotypes, and it's been shown that in the past, misapplication of discriminatory stereotypes against particularly affect women of color. So it doesn't address any of these racist implications. It should also define key terms. It's using terms about like genuine concern. If there is a genuine concern, and things must be handled sensitively, although it doesn't define what sensitive means. It doesn't define what genuine concern means, and it's got all of these terms that just leave things so incredibly open. I mean, yeah. I mean, how does one ask? Sensitively? I'm sorry, you look a bit mannish. Were you born a male? Like, is there a sensitive way of saying that? And what's a sensitive way of saying, sorry, I don't believe you? Can you prove your biological sex? Anyway, these terms need much better explanation. So concrete examples of what's needed, and particularly examples around where people are being approached incorrectly. So, I think reworking examples around people being approached incorrectly would be much more useful. It would also give demonstrations of what to do around applications of checking birth certificates and other forms of checks that could be deployed, but it hasn't covered any of those. It should establish high thresholds. Far clearer and significantly high thresholds need to be established when asking about birth sex and when it could ever be deemed necessary and appropriate, because it seems to create like a really low bar, just a subjective assessment of any untrained staff. So yeah, it needs to be clear about what these thresholds are, and they need to be set high. Prioritize least intrusive means. Yeah, it doesn't talk about the prioritization of different means. Like if you have to ask somebody about their sex, which methods should you use? Which methods would be appropriate, and which ones should you try first? Like all of these things aren't covered. I think probably the reason why they're not good is because giving people instructions on how to harass women about their gender in bathrooms is, it doesn't look good. So I think the more that they're drawn into the weeds of having to explain these things, the worse things go for them, because in application it's horrific. Anywho's, the term objectively false in 2.26 it is necessary, if it is necessary to ask a person's birth sex, consideration should be given to whether it is reasonable and necessary to ask for evidence of birth sex. In many cases, it will be sufficient to simply ask an individual to confirm their birth sex. A service provider may make the rule that if somebody is asked about their birth sex and chooses to answer objectively falsely, it will be grounds for exclusion from that service. Now, the words objectively false are very strong to use in a context where we're talking about people, not just trans people, but intersex people, or people who have had errors on their birth certificates and things and had to have them corrected. The term objectively false is offensive and objectively untrue. To be honest, actually, one of the points that that perhaps I should have raised earlier on, it might also feature into any other covered points at the end. Oh, I forget it now. Yeah, no, it's gone. Okay, cool. I'll come back to it. Right. So moving on, we've got 2.28, GRC concern confirmation. The suggestion that the service providers might confirm GRC status is really problematic and potentially unlawful under the Gender Recognition Act in Section 22. This recommendation should be removed or completely rewritten to state unequivocally that service providers cannot investigate or demand GRC status, respecting an individual's right to privacy and the confidentiality afforded by the GRA. That needs to be much clearer. In fact, the guidance must be more strongly and it must more and clearly state that targeting individuals for question about their sex based purely on their perceived gender identity could be discriminatory in and of itself. So, you know, you'll be targeting somebody for a perceived characteristic under the gender reassignment characteristic. The Ask Everyone approach covered in 225 earlier on, it covers the Ask Everyone approach. It is likely to be best to adopt the same approach with everyone. That really needs to be mandated as default. Because in all but the most exceptional circumstances, it is possible to ask everybody and not just where practical. Because, you know, we're talking about protecting people's rights. It's not right to just target people who you think, oh, well, they look a bit trans. Yeah, so there we go. I think, yeah, I mean, there's just something inherently unreliable and discriminatory about allowing people to make subjective opinions on people's birth sex, and it's going to cause problems. It's also really not fair at all on frontline staff who are going to be expected to approach people and say potentially inflammatory and confrontational things to them. I mean, how many people are going to be appreciate being approached and told that they look like the opposite gender? I like to be asked to do that as part of my job. Yeah. Okay, let's move on to 223. New content on defining sex at birth. I mean, there's an oversimplification and omission of intersex people. So the code states in 231 that sex is a protected characteristic and refers to male and female, and that the Supreme Court ruled this means biological sex at birth. Now, this definition isn't clear or comprehensive because it entirely omits any mention or consideration of intersex people and people who are born with characteristics that don't fit in typical binaries. So forcing a strict male-female binary based on sex at birth without acknowledging or explaining how the act or code applies to intersex people renders the explanation of legal rights and responsibilities profoundly unclear. and inadequate for this group. So yeah, it needs to address that properly. It's also again unclear how it interacts with the GRA. It says the GRA does not change a person's sex for the purposes of the Equality Act, and while that does reflect the Supreme Court ruling, it isn't clear about the remaining scope for the purpose of the GRC, and it doesn't tease apart, which aspects and how they fall, because it's not, those things aren't always clear. So yeah, it's unclear also the interaction with gender recognition or gender reassignment protections. So paragraph 234 states sex does not include gender reassignment. Well, now, while these are distinct protected characteristics, the code doesn't clearly explain how the service provider's responsibilities to avoid gender reassignment discrimination interact with their responsibilities when applying single-sex provisions based on biological sex at birth. So, for example, if implementing a biological sex ruling for a service foreseeably causes a disadvantage or harassment to a trans person because of their gender reassignment, how are these conflicting responsibilities to be clearly navigated by service providers or understood by trans individuals? So, and there are some services that really are only apply to women as a biological birth category and as inclusive of trans women, So yeah, and there are some services that don't have enough numbers to run trans inclusive versions of their services. So anyway, but yeah, it's unclear how these protections will interact. And by uncritically adopting the term biological sex at birth as the sole definition without acknowledging the scientific and medical complexities as raised by bodies like the British Medical Association regarding reductive definitions, the code creates a false sense of clarity that obscures the real world biological diversity and lived realities of trans people. So especially on HRT and intersex people, because their biology isn't exclusively one or the other. It's very much the case that hormones instruct a body on how to arrange itself. And although not all aspects change depending on what stage those hormones change, but to describe one's biology as your biological sex and your sex at birth as being synonymous, and by using terms loosely in this manner, it's incorrect, and it reflects poorly and creates ambiguity. Comparative sex discrimination as per 234. A trans woman with GRC believes she has been treated less favourably as a service provider than a cisgendered woman was treated in simulation. She wants to claim sex discrimination. So I'll make a note there. Okay. It states her comparative sex discrimination is a person of the opposite sex, biological male, as she is defined as male for the purposes. However, the discrimination she experiences may be because she's a woman. She's affirmed in her affirmed legal gender for most purposes and was treated differently to other women. The code doesn't clearly explain how the protection from sex discrimination related to their acquired gender, where this is because of their perceived sex, practically functions when the primary definition of her sex and her primary comparator for the act are based on her birth assignment. So her comparator for her sex would be her sex, according to this. So how does a service provider understand their responsibility to avoid sex discrimination towards her as a woman if the code primarily defines her as a man for the EA purposes? It leaves the service provider unclear about their rights and responsibilities in that regard. And yeah, that would need to be properly teased apart. That was the last question for that section. I'm going to move on to question 18, that pertains to change 2.4, the updated description of the protected characteristic of sexual orientation. So the code must explicitly clarify whether same-sex in paragraph 241 refers to same biological sex at birth or same lived affirmed gender when discussing the sexual orientation of individuals. Okay, so sexual orientation. So yeah, I mean, I know that they have already given terms, but I think that they need to be more explicit here in how they're defining it. They should say, given the successful argumentation that people are not attracted to a certificate in this area, the guidance should be clear about how the interpretation of biological sex over certification is applied here, and how it avoids inferring that people are attracted to sex at birth and birth certificates, because it was a very strong part of the argumentation and the reasoning for adopting this terminology was people aren't attracted to your certificated sex, whereas they seem to be intending here that people are attracted to people's sex at birth and their certificated sex at birth. So this really needs to be picked apart, how that part of the ruling is being respected here. It should also explain how a married trans person, let's say a married trans with a gender recognition certificate, how they can access services, and specifically how a couple is considered to be a heterosexual couple for the purposes of the Marriage Act, but as a gay couple for the purposes of the Equality Act. On what basis can they access services? You know, like a couple-based services. The Marriage Act would classify the marriage of a trans woman and a cis guy as being a heterosexual marriage, of course. So that's the the Same-Sex Couples Act. So the Equal Marriage Act in the UK is called the Marriage Same-Sex Couples Act 2013. And that would classify that couple as being a straight couple, whereas the Equality Act now classifies them being a gay male couple, and that involuntarily classifies the male in that situation as being gay, which I think is problematic. It also creates a very strange situation in law that could have far-reaching consequences when different parts of law consider them to be different sexual orientations and offer them, I would assume, different protections based on those considerations of them as being different sexual orientations. It's just baffling. So if it refers strictly to biological sex at birth, the code has to explain how the orientations of transgender people who define their orientations based on their actual gender identity, and the people who are recognized as their partners, they also would recognize their sexualities, typically on the basis of their inclusive gender identity. How on earth this is respecting any of them? All of these people who are in these actual relationships are having their relationships redefined for them. So yeah. The code should do this, providing explicit examples illustrating the different sexual orientations of couples and how they're considered and how they fit together, particularly with relation to the Marriage Equality Act. It should provide explicit examples of how the Equality Act considers the partners of trans people. I think that probably covers that section. I'm going to skip ahead a little to 246 and the statement that gender reassignment and sexual orientation are unrelated. Gender reassignment is a separate protected characteristic and unrelated to sexual orientation, despite being grouped together. This is untrue and it is divisive. It's also not how the vast majority of the LGBT community perceives this, and it's completely inappropriate for a code to put that kind of wedge in there. One only has to look at any LGBT history book to realize that's an obvious lie and an exercise likely in intentional cruelty. The rigid definitions of lesbian, woman, and gay men based on the attraction to same sex, where that sex is somebody's certificated baby sex, also clearly it fails to explain how the sexual orientations of intersex people whose biological sex at birth may not fit in a simple binary are understood or protected. In fact, we have people who would be XY who might have a deficiency in the production of 5-alpha reductase. Now, these are people who are XY. They just didn't get a particularly large bump of testosterone because they don't produce dihydrotestosterone or produce limited amounts of dihydrotestosterone. And these are people who will go on in puberty to have descending testes, grow penis, testes, be XY males, and are they no longer allowed to alter their birth certificates? It's absolutely ridiculous, and the only reason why we could consider this as being the case is as a matter of intentional cruelty. Yeah. Okay, I'm going to move on to the next section and to question 21 in section 4.1. But before I do that, I will give you a break because we've been recording for quite a while. So go and grab a cup of coffee and then join me on the next video.